This moment is proudly brought to you by Etosha Gardens. A journey of life. With every drop of water comes life. With every life comes memories. Each memory that is shared creates a legacy to be remembered. Etosha Gardens, your cemetery of choice. Welcome to Rufu, Rwakarongeka, proudly brought to you by Etosha Gardens, your cemetery of choice. Being able to share with you some very positive insights that have to do with all things relating to one's estate. Now, today we're proudly hosting the Master of the High Court of Zimbabwe, Mr. Eldad Mutasa, shedding light on very pertinent issues that do affect you, and being able to make sure that all things that come to that one thing that is standard, which is passing, are in order. Once again, thank you so much for joining us.
Thank you for having me.
Now, in appreciating the work that takes place with the Master of the Court, one has to appreciate that there are expenses, there are costs incurred by those who have the service that is offered by the Master of the High Court. Why can't the office exempt some people from paying the 4% after assessing the circumstances that would have taken place?
Okay. It's quite a tricky question, Mr. Gwaze, but I think it arises out of lack of appreciation of the estate administration processes. For starters, we do not ask people to pay. What should happen is that the estate is the one which should meet its expenses. But because people want to preserve certain assets, they offer to contribute so that the asset either is not liquidated or sold, and they keep it. So much that it appears when you go out there, some people want to talk about these expenses. They make it like it's a burden on them as the spouses or as the children. It's not. In other countries, they don't even talk to anybody. They simply take out whatever is due to the fiscus and recover, and then they share the remainder. But if in the Zimbabwean context, it's the estate which should meet its expenses and liabilities. So it depends on the circumstances surrounding each case. There is no exemption. Because if I leave something, there is a fee that should be paid, which is currently 4% of the value of that estate. But we can arrange with the executors, especially in circumstances where you can see that the estate is not liquid. There's only one asset, one house, which happens to be providing the roof above the head of the children or the surviving spouse. Honestly, naturally, we wouldn't want to take away that roof. You see, we would want to do that. So we come up with mechanisms where we get into payment plans.
Yes.
Yes, payment plans which are quite reasonable. Which are quite flexible, but we assess circumstances.
I was about to say, surely it's a case by case.
It's on a case by case basis. You will be surprised that some people will be making noise out there about failing to raise $400, which can be paid in Zim dollar equivalent. Right. If you assess the estate, you then say, okay, here's a widow. She's 72. she's the one staying in the property. We want 400 or equivalent, because that's the average for high density properties. Want 400 US in equivalent. Then she says, I absolutely have no cent. I said, okay, you then look at the children listed. The other one is a CEO of a very big company. The other one is a journalist who earns some decent. The other one is a teacher. The other one is a lawyer, and so on. So you then ask yourself, are all these people really failing to, or it's a question of attitude? Right. Because what I can tell you is no one wants to pay taxes voluntarily. Right. That's we all know that.
So then, is it not appreciating? You said it very clearly at the beginning, Mutasa, that it is the estate which is paying this fee. So I think quite simply the privilege of being able to be given this estate, because it wasn't yours before.
It wasn't yours. That's if only people would understand it the way you are doing, it will make our job easier, Mr. Gwan. It's not yours in the first place. Right. And we are talking of people, adults who are over 18 years, well over 18, who are even employed elsewhere. Right. You see? And we are not saying, guys, get deep into your pockets to pay us. No.
Is there a concern? Maybe let's try and dig into this particular problem. Is that there's a perception to some that it is theirs.
Yeah. So it's a wrong perception.
And then now have to pay the master of the court to get what they believe is already theirs, is where the challenge is.
Yeah. And it's a serious misconception.
Right.
It's very serious. They will be very misguided. Right. It's not their asset.
Right.
They have interest. They have certain rights. But these rights, they can only enjoy them upon meeting certain obligations, which are usually financial. You see. So we are not disinherited. We are simply saying, look, your father left only the house. There's need to pay $400. Right. Look around. If you are staying at the property, you may be interested in keeping it because that's what you consider your dwelling place.
Right.
You see. But you don't just keep it. It's not yours. You keep it provided you have met the financial obligations. Right. You see, the taxes, which is just 4%.
4%. And you bring up 4% as a just. Now, you also did acknowledge earlier that for those who have little, certain contributions can be made over time gradually. Maybe you could share with us for some who may find themselves under such an unfortunate circumstance where they don't have much and they get this property that's worth $40,000 and then now $400 is all that's required. What measures are put in place to be able to facilitate for them to?
Because what we've tried to do is to engage these executors, because it is the executors who have responsibilities to pay liabilities. So in most cases, I would say 95% of our estates, executors are surviving spouses. Here she is, or here he is, in a mansion. You see, it's a mansion. It's a 5-bedroomed, and so on. So we in some cases we've engaged them and say, do you really think you need such a huge house? You see, can't you think around probably selling it and get something which is cheaper to maintain? Because circumstances have changed. Let's face it.
That's the reality.
It's the reality. If you keep staying in an expensive neighborhood, then how do you, even if you are to be exempt to pay the tax, right. But how do you maintain the rates, everything else and stuff? But I can tell you, the same people who do not want to raise the 4% are capable of raising certain amounts for either rates and other expenses. Yeah, they are. They can easily, but because this is going to government, they will tell you no ways. Why should we? This is the state pay. You see, they ask for, but it's the law. You see, and every country survives on taxes in one way or the other. And death duties are a practice in every country.
Right.
And in our case, a comparison study will show you that we are not on the expensive side. Because there are other interventions that we have done to make sure that it's not really a burden to the beneficiaries. Because already they are not supposed to be paying. It's the estate. But it just happens that the estate is not liquid.
Right. Now, maybe I could also just expand a bit further with the situation where we've got someone who has got a small asset in their estate, but there's a liability at the bank.
Yeah.
A small loan was taken, very small loan of maybe, let's just say $1,200. Very small loan was taken. But then now upon the passing, you then also highlighted previously that you are more in the position of firstly having to address the liability.
Yes.
How then do you manage that kind of scenario, and do those kinds of scenarios come up where the family or the beneficiaries then now are that much badly affected that even the fee that's required can't be covered going forward?
It brings back to that point that I tried to highlight, where I said they can raise fees for other expenses. They can raise funds. When it comes to such a loan, where probably the deceased owed the bank something like 5,000 US against an asset which is worth 40,000.
Right.
It's up to the beneficiaries now, because the estate is there. There is the property which belongs to the deceased. And in most cases, such liabilities have resulted in the asset being sold. To meet, not necessarily to meet master's fees. No, we are not that insensitive.
Right.
But to meet such liabilities. And also in most such cases, they always find ways to raise the 5,000.
Right.
It's rare for the property to be sold, unless the debt is very, very high. But if it's around 5,000, 3,000, they'll look around, do the engage and so on. But when it comes to 400 US for master's fees, no effort.
Right.
Usually they don't look around, they don't run around. Just because it's being paid to the government.
It may seem like a roundabout question, but I think maybe you can simplify this for me. What about in the instance where someone then now has got the liability, but wants to take on that liability without having the asset liquidated? Is that possible?
It's possible.
It's very possible.
All you need to do is, if the liability is 5,000, look around for 5,000,
Right.
Put it on the table, and if the creditor
Right.
takes it, then you're good.
I ask that
Then you
because
keep the property.
I ask that because of concerns with arbitration.
Yes.
The creditor may rather have an asset.
No. When it comes to deceased estates,
yes.
creditors they can't elect to take the asset, even if it was provided as collateral.
Right.
The idea, collateral, is you are simply hedging against against the debt. So you're extending a loan, and they're saying, I'm holding this in case you don't pay me. So in case I pay you, what happens? If I pay you, you return whatever. You see, yeah. So they don't have a choice to take the asset when the liability has been settled. They can't do that.
Right.
It's improper. It's not allowed at law.
Now let's get into some administrative aspects that come in with your office. Now, time frames within which the estate should be registered, but more importantly, I think you touched on that before. More importantly, penalties for late registrations.
Yeah, the penalty for late registration. It's just that we haven't been enforcing it.
Sure.
Yeah. And but it's there in our acts. I think it's 30 days imprisonment, or a fine, or both, for failing to register an estate. One can be imprisoned for 30 days.
Right.
So when you are released, you're expected to then go and register within 14 days. If you don't register again, you may be taken back. You see, to prison, or you can be fined. And you continue being fined until you register the estate, or you'll be incarcerated. So there is a penalty. We have not been really enforcing, because our conscience was like telling us that we haven't done enough in terms of awareness. Though it's not an excuse. Ignorance of the law is not defense.
Mutasa, you seem to bring up the conscience of your office quite a bit. It seems as though that there's a lot to be able to manage in having to deal with human faces. Yes, morally, ethically, you bring that up. How then would you advise the public to better understand the extent to which you are trying to be able to accommodate those who have gone through something like losing a provider in their family?
Yeah. All I can say is, for starters, people should know the law. The law is there for a purpose. And they cannot wantonly disregard the laws of the country. We talk of sovereignty. We talk of rule of law. There will be no point in having a law and not respect it. So sometimes a departure from certain processes, it should be within certain parameters where it's safe to do so. So when we put moral conscience, it's not like people should then take advantage of that and fail to observe the law. Sometimes when we extend these deadlines, we are doing it because we are saying we come from society, we appreciate certain dynamics and certain challenges, and but that is not to say people should not put effort towards observing the laws of the country. We've had cases where we have 5 beneficiaries, and 2 elect to have their shares in cash. This is in reference to a house left behind by the deceased parents. 5 children, 2 are saying, we want to inherit in cash. We are not interested in staying at the property. And then we have 3 who are already housed there.
Right.
And they are saying, we want to inherit the house. What happens? You see, people don't even know. But the reality is, legally, if one child out of 20 indicates that he or she wants his or her share in cash, it binds the executor. It binds the master. You see, so the property can be sold at the request of one person, unless these other children can buy out. But you are talking of people who may be 22 years, 19 years, 30 years, but not gainfully employed, and they cannot afford to buy out. What then happens? You see, if you then look at the law, the property simply has to be disposed of. Right. We can't then say, because these are outnumbered, the 2 who want their shares in cash, they are outnumbered by the 3 who are staying at the property. It doesn't apply.
Maybe also you could share with us, as difficult as that experience may be, how it transpires. Yes, the one decides to take the cash component. Now the asset needs to be liquidated. Maybe you could give us the steps of the notice that's then given, and then from there, yeah.
We are reluctant as an office to be selling or sanctioning self-property, especially in circumstances where it directly affects a beneficiary who is enjoying use of that property, who is in occupation of the property. But legally, sometimes it's unavoidable. Because once those who are interested in keeping the property are not in a position to buy out, where the executor approaches the master for consent to sell. And we conduct an inquiry as an office. We summon them. What has necessitated the sale and so on. Then we look at the facts and the law. And then you realize, okay, we are compelled by the law to issue the consent to sell. Because if it happens the other way, that we are taken to the High Court by the two who want their shares in cash, I can assure you almost 100% they are likely to succeed because they are protected by the law. Remember, we are talking of an asset which belongs to a deceased person. No one owns the asset amongst the 5 beneficiaries. It's just that they may have some morally compelling circumstances. But whenever the two collide, the morality and the legality takes precedence. You see, the legality takes precedence. So at the end, the house is sold. That's when you hear some of the stories, which are usually sensationalized, where the headline may say, Master of High Court sells house and the 3 children have become destitute.
Right.
And they have neighbors coming and showing sympathy and so on, creating a situation like we are the most cruel people in this world.
Right. It's
all down to our failure to plan as individuals as we live. You see, it's the lack of unity within the family. Because in these cases where a person will just elect to say, I want my share in cash, if they are united and they're talking with one voice to say, we want to keep the house, you see, and they can afford the administration expenses, we will not sell. But if they are not united, what do you expect the executor to do or the master to do? So some of these stories we read where a property has been sold, if you dig deeper, it's not the executor's fault. It's not the master's fault. Of course, we may have an Iran executor who may be irresponsible, but there are very, very few.
I'm gonna hold you there as we take a short break and be right back with more. Stay tuned.
This moment was proudly brought to you by Etosha Gardens. A journey of life. With every drop of water comes life. With every life comes memories. Each memory that is shared creates a legacy to be remembered. Etosha Gardens, your cemetery of choice.